In recent years, the Nigerian judiciary has become a spectacle of intense scrutiny as the search for justice appears more elusive, no thanks to the high level of interference by external forces and the perception of corruption allegedly perpetrated by some members of the hallowed bench. In October 2016, under the guise of exposing corrupt judges, the homes of some judicial officers were invaded by the officials of the Department of State Security Services, DSS, in such a Gestapo manner never before witnessed in the country's history. None of those judicial officers have up till date been successfully prosecuted. That, to many, was the beginning of what would later become a predictable pattern of assault, not just on individual judges, but the institution of the judiciary itself. It was with little or no surprise then when the head of the judiciary, Justice Walter Onoge himself, was targeted. For a man accused of non-declaration of assets, the facts as to his misdemeanor were no doubt in the clear knowledge of the federal agency that screened him for the job, that's the DSS. It was therefore within the powers of the All Progressives Congress-led executive, headed by President Muhammadu Buhari, to stop his 2017 appointment based on the said facts. But 2 years after his appointment, with just a month to a general election, with obvious judicial fallouts, an alleged old sin was exhumed, and in the most brazen and unconstitutional manner, the judiciary suffered yet another executive battering amidst widespread condemnation both locally and internationally. But if the judiciary has over the years been a victim of external assault, the most unconscionable damage to its independence and integrity will be that which is self-inflicted or allowing itself to be a willing participant of its own misfortune. The 2019 presidential election petition and the 786 other election petitions filed in the different tribunals across the country therefore present before the Nigerian judiciary the most colossal test of fairness, equity, and integrity. How it handles these contentious political cases will go a long way in determining whether or not the institution of the judiciary can rise up from the labyrinth of complicated misfortunes and redeem the trust, confidence, and reverence Nigerians once had on the courts and its judges. For instance, the petition filed to challenge the outcome of the presidential election by 4 political parties have been overshadowed by the fear of compromise and bias in the composition of the panel. The president of the Court of Appeal, Justice Zainab Bukachua, has been in the eye of the storm since she appointed herself as the presiding justice in the 5-member panel hearing the presidential election petition. Ordinarily, few would have challenged the competence, objectivity, and experience of Justice Bukachua to serve on such high-profile case, but facts surrounding her personal life, with specific reference to her marital and familiar relationship with prominent members of the ruling APC, imposes a moral burden on her and raises legitimate fears of her of neutrality in such a delicate and politically sensitive case. The international standard, the Bangalore Principles of Judicial Conduct, which has been adopted by several judiciaries and legal systems unreservedly around the world, states unequivocally in value 4.4, a judge shall not participate in the determination of a case in which any member of the judge's family represents a litigant or is associated in any manner with the case. Drawing from the internationally accepted Bangalore Principles of Judicial Conduct, the National Judicial Council of Nigeria modeled its Code of Conduct for Judicial Officers, where it states as follows in Order 7, Rule 2. If it appears in respect of a matter before him or her that the judge or a member of the judge's family or other person in respect of which the judge is in a fiduciary relationship is likely to benefit financially, the judge has no alternative but to withdraw from the case. In 1998, the British House of Lords, in a landmark decision, upturned the arrest and extradition of former Chilean dictator Augusto Pinochet for crimes committed against humanity because it was discovered that one of the 5 judges, Lord Hoffman, was a director in the International Charity Limited, owned by Amnesty International, an organization that was earlier appointed by the court as interveners in the case. For an issue that many would have considered as innocuous, a new panel of judges not only upturned the decision, but held that Judge Hoffman stood automatically disqualified from hearing the case. Such is the sensitivity to which a reasonable suspicion or likelihood of bias is, as it goes to the root of justice itself, which is the right to a fair hearing or fair trial as captured not just in the United Nations Declaration of Human Rights, but also in Chapter 4 of the Nigerian Constitution as amended and captioned as Fundamental Human Rights. The revised Code of Conduct for Judicial Officers as enacted by the National Judicial Council (NJC) is clear on what may constitute a burden of impartiality. Rule 2, Sub 10 states that a judge shall not participate in the determination of a case in which any member of the judge's family represents a litigant or is associated in any manner with the case. For the avoidance of doubt, there are established 4 parameters that should be considered in conflicts of interests. A. Personal connection to one of the parties. B. Personal knowledge of the facts of the case. C. Familial relationships such as marriage. And D. Financial interest in the result of the case. All of these are formulated in the recusal law, which provides that a judge should disqualify himself on the basis of being a spouse of a person in the case within the 3rd degree of relationship. Also, if he is known to have an interest that could substantially affect the outcome of the proceedings, which include pretrial, trial, appellate review, or other stages of litigation. In the case of Justice Bukachua, clear and uncontroverted evidence proves that Justice Bukachua is the wife to a prominent member of the All Progressives Congress (APC), Adamu Mohammed Bukachua, who is also a senator-elect on the same political party of a president whose election is being challenged. Incontrovertible fact also indicates that Justice Zainab Bukachua is the biological mother to another prominent member of the APC, Aliyu Abubakar, who contested for the governorship of Gombe State on the platform of the same political party, the APC, whose victory is being challenged before Justice Bukachua. Under the present circumstance, the NJC Judicial Code expects Justice Bukachua to recuse herself in line with other 12, Rule 1, C, D, and I, which states, a judicial officer should disqualify himself in a proceeding in which his impartiality may genuinely and reasonably be questioned, including but not limited to the instances where he knows that he individually or as a judicial officer or his spouse or child has a financial or any other interest that could be substantially affected by the outcome of the proceeding. He or his spouse or a person related to either of them or the spouse of such person is a party to the proceedings or an officer, director, or trustee of a party. The demand for a judicial officer of her status to honorably step aside couldn't have been more persuasive. We hold the view that ordinarily, Justice Bukachua should not have waited until the issue of the likelihood of bias is raised against her before taking steps to recuse herself. In fact, she should not have listed herself as a member of the Presidential Election Petition Panel in the first place, not to talk of appointing herself as the presiding officer. Will the ordinary man on the street perceive her to be a fair arbiter? Irrespective of her judicial oath to do justice to all manner of men without fear of favor, would Justice Bukachua not be putting herself in a position of possible compromise in a case seeking to discredit the election victory of the political party of her husband and son? It is our firm opinion that in order to save the Court of Appeal and by extension the Nigerian judiciary, the dilemma of a further deepening of loss of confidence, Justice Zainab Bukachua, in the light of what have so far been disclosed and clear provisions of the Code of Conduct for Judicial Officers, should honorably resign her membership of the Presidential Election Petition Panel forthwith, and any other matter that may call her integrity and objectivity into question. And in line with the tradition of hierarchy in the judiciary, the next most senior justice of the Court of Appeal should be appointed to preside over the presidential election petition. The same is also true of the appointment of members of the tribunal under her. Indeed, all the panels constituted by her should be reviewed. With the judiciary as the final hope of the common man, this is just the perfect opportunity to do the right thing, stay on the path of principle, morality, law, and justice. It will be traumatizing for the vast majority of Nigerians who yearn for justice and who passionately sympathized with the judiciary over the various attempts to undermine its independence and who demanded for it to use every opportunity to internally cleanse and reassert itself if it fails to take deliberate steps to erase the unfortunate stains on the pages of its history. Like they say, it is only by so doing that justice will not only be done, but seen to be done.